This is U.S. Bank versus Patterson.
Good morning, Your Honors.
Good morning.
May it please the Court, Andrew Arias on behalf of Appellant U.S. Bank. Your Honors, this appeal is of an order granting an involuntary dismissal on rehearing. The case proceeded to trial. A judgment was entered in favor of U.S. Bank. Upon rehearing, the Court reversed itself. And I'd like to simply remind the Court that the standard of review on this issue is de novo. And so the evidence must be viewed in the light most favorable to the non-movement, which is U.S. Bank in this case. The central issue on appeal is whether the notice of default in this case was sent to the correct address, to the notice address. To provide the Court with a bit of background, the subject case involves a traditional Fannie Mae mortgage, which contains the standard paragraph 22 requiring notice of default. I'm sure the Court is aware of these types of mortgages. The paragraph 15 is also at issue. Paragraph 15 requires that the notice be provided to the notice address. Of course, these are conditions precedent to foreclosure pursuant to the terms of the mortgage. I want to turn the Court's attention to the evidence and testimony presented at trial, beginning with the defendant's testimony that she moved to the Sandkey address as referenced in the briefs in 2006. The Sandkey address was not the subject property, was not the address on the mortgage property.
Does not the mortgage say specifically that the notice is to go to the property?
It
that
says
would
that
not have been Sandkey, is that correct?
That is correct.
All right. And there's further language in the contract that says unless the borrower notifies of a different address. As I understand from the record, there is no such notice from the borrower to the bank. Is that correct?
That is correct. There is no evidence.
Now, the 4th District seems to have confronted this issue, or at least somewhat in Bloom and a variation on it in Hawthorne. Bloom would seem to hold against you, and Hawthorne would seem to create an exception, because if I recall Hawthorne correctly, on the signature line on that note, the other address appeared. So tell me, how does the appellant in this case get around, or should they need to get around, Bloom?
Well, the holding in Bloom is very limited as far, well, I should say the opinion is limited insofar as it does not discuss any other evidence in the case. It doesn't discuss if there was any other evidence regarding the defendant's address. It simply notes that the notice was not sent to the property address.
Isn't that required by the mortgage?
It's required that the notice be provided to the notice address. However, there is a case out of the...
So what you're saying is the bank failed to perform, but you're going to provide an excuse why performance is not necessary?
I'm going to say, correct, Your Honor. There's a case out of the 4th DCA that's cited to in our briefs, the Caraccia versus U.S. Bank case. And in Caraccia was a case that involves a similar fact pattern to the extent that there was no notice of change of address on the record, or in the record, I should say, and yet the 4th DCA affirmed judgment for the bank in that case because there was other evidence in the case which indicated that the bank had the correct mailing address. And in Caraccia, the 4th DCA even goes out and says, well, if we look at this from a practical point of view, the fact that the bank sent it to the correct mailing address, even in the absence of a notice of change of address, is not only sufficient, but it's actually encouraged because the bank is ensuring that the borrower receives the notice at the proper at the address where they actually reside.
I don't know how you get there when I have a default rule in the mortgage that says you send it to the property. So you have an ad hoc explanation that, well, I think we sent it to the mailing address and that's sufficient.
Well,
I'm just trying to understand how that works with the default provision in the
how the sending of the notice to a different address.
Yeah. Because the bank's ignoring its own obligation to send the notice to the property address.
Well, but the bank is sending the the notice to an address to which it reasonably believes that the defendant is going to receive the notice of default. And so...
Did you move for reformation?
No. No, there was no motion.
That's a reformation argument here. I mean, you would be asking a court to rewrite the terms of a document that your client prepared.
I think it's more of an equitable argument based on the fact that we're trying to ensure that the defendant receives notice of default and has an opportunity to cure. And
Well, would you say that this clause is a material provision of the contract to give notice to allow for a cure?
I'm not certain that it's material to the mortgage. It certainly is a condition preceding to foreclosure. I don't question that.
Material
But
breach, isn't there some standardized contractual law that says a material breach by one party excuses the other party from further performance?
but I don't believe it is a material.
No one's argued that, so we'll just stop there.
Right.
Isn't your better argument that she's not prejudiced?
Well, and that is another argument that was raised. The fact that there are cases, and I apologize, I'm kind of got thrown off here, but correct, Ms. Patterson did not testify that she was prejudiced by not having received the notice of default, and there is case law on the issue of prejudice. If the failure to comply with the condition precedent was not material insofar as it didn't prejudice the defendant, then the court can overlook that failure to comply with the notice, absent some prejudice by the defendant.
Who has the burden of establishing prejudice? The breaching party or the non-breaching party?
I would say that the non-breaching party must establish some sort of prejudice caused by the failure to provide.
Well, they're not being asked to excuse performance. The breaching party in this case is being asked to forgive us for not performing according to our contract because we have an excuse to avoid it because there's no prejudice. So it would seem, wouldn't you think, that if you breached the contract, you would have to show that the other side sustained no prejudice?
I think the case law goes to the bank's burden to prove compliance with a condition precedent, or in this case, because there was no notice in the record of change of address, there was other evidence on the record regarding the defendant's mailing address. At that point, I think the burden shifts to the defendant to prove that they were prejudiced by not receiving the letter.
Would it seem to follow that if I'm not notified or if the party is not notified of their right to cure, their right to reinstate even after breach, that they have suffered some form of legal prejudice?
If there are facts bearing out the issue of, well, had we received, for example, had we received notice of default, we would have tendered payment.
Well, did she testify that she never saw because her late deceased husband the doctor used to handle the stuff, so there's no record evidence that I could find in this case that she was in fact on notice. Now, arguably, to her husband, she may have a constructive notice of it, but on the face of her fact, there's very little evidence there to suggest that she knew about it.
Correct, and she did testify throughout the trial that essentially her husband handled the paperwork with regard to the mortgage, so she seemingly was unaware of any issues there. And that brings me, to Your Honors, to the evidence at trial, which was the evidence of residence at the Sankey address, which is where the notice was mailed to. The first piece of evidence is the defendant, in page 67, lines 7 through 9 of the trial transcript, testified that she moved to the Sankey address in 2006. That is about 5 years before the notice of default was sent. The second piece of evidence I want to turn the court's attention to is what's referred to as the hello goodbye letter, or the notice of servicing transfer, and that's on record page 234. It was admitted into evidence. It was sent to the Sankey address in June of 2010, And that letter essentially tells the borrower, hey, U.S. Bank is taking over the servicing of the loan. Please stop remitting payments to the original lender and begin remitting payments to U.S. Bank. That was in June of 2010. The next piece of evidence I think is significant is the payment history that was admitted at, and specifically record pages 256 and 257. The payment history reflects that U.S. Bank received several payments following the notice of servicing transfer to the borrower at the Sandkey address. Several payments between June 2010 and February 2011. And I think that's significant because it shows that the defendants, I think it shows the defendants likely received the notice of servicing transfer at the Sandkey address. Otherwise, how would they have known where to remit payment to, given the change in servicing?
As I look at the June 8, 2010 letter, the one that you say is the hello, goodbye letter, is there anything on the face of that instrument that would notify the appellees in this case that by sending a future payment, you are altering the terms of your underlying mortgage and your right to receive notice at a particular address in the event of a default?
If I may, Your Honor, promptly review. I do not believe that the letter contains that language.
Does the law generally require that your right has to be knowingly waived?
That your right has to be knowingly
If you
waived?
have a right, in order to get a waiver, you have to know and intend what you're doing?
I believe so, Your Honor. Next, the notice of default admitted at record page 271. Again, that's I guess the central exhibit to this appeal, was sent to the Sandkey address in February of 2011. The defendants were served with process of the foreclosure at the Sandkey address, and they thereafter filed a pro se answer from where they notate the Sandkey address as their residence. So taking all these pieces of evidence together, I think the reason